Do we test to make sure that people can hear on WebEx the sound? I think they probably can, but we're gonna get started and they'll let us know if they can. All right, everybody. Welcome to the third meeting of the Baltimore County Working Group on Resource Coordination to support victims of sexual exploitation, violence, and domestic abuse. My name is Henry Caligari. I'm the Senior Coordination Manager for Public Safety and Accountability with Baltimore County. And I want to thank everybody for coming today, either in person or via WebEx. And just to, before we get rolling, I did want to provide a little bit of context. So if you saw the agenda for today's meeting, we've got really two presentations, one on protective and peace orders by Officer Kelly with the Baltimore County Police Department, as well as a conversation about these issues the working group covers with a focus on the schools. So we have a presentation from Tiffany Eshelman from Baltimore County Public Schools and Anthony from Baltimore County, or from Towson University as well. So both will discuss what they're seeing on the ground level as well. And then I know the first couple of meetings have been sort of focused on setting the table and going over the big picture issues that we're seeing in Baltimore County and as well as statewide regarding sexual assault, exploitation, violence, et cetera. And then the hope is that as we move into the summer, we're going to start digging more into the data. So the providers in the room know that I've reached out to see what data is available to analyze and go through. That's part of why we have BC Stat in the room. We have Chanello and Lindsay. Lindsay, who's on the WebEx, they will be helping out with looking at that data and as well as some information from the police department as well. The hope is we can get into that at our June meeting and really start to dig into the details. As we've established the 4,000-foot view, now we have the chance to look at the more, I would say, the more minute information that we need to make recommendations to the council and to county government as a whole and the state of Maryland for any changes or better ways to make sure that the needs of survivors are being met. I'd also be remiss if I didn't mention that yesterday the county executive, along with representatives from GBMC and Turnaround, the state's attorney's office, BCPD, discussed the significant update that sexual assault survivors who received treatment at GBMC between 1977 and 1997 can reach out to a new hotline and email address to either opt in or opt out of receiving information about sexual assault evidence in cases that were saved or never tested. So that's a major update. There are more than 1,000 of those cold case slides that have been sent to a DNA lab or lab for DNA testing since November, and they should all be tested by the end of the year. So that's a major development. And the Maryland Coalition Against Sexual Assault is the point person there for handling the outreach on that. So that's a major development that happened yesterday. And I wanted to make sure that those, I'm sure everyone in this room is tapped into that, but for those who may be on WebEx or who are maybe not in that particular area or aware of it, I wanted to make sure we provided that context. And with that in mind, if we can just go around and folks want to introduce themselves. I know that we're on for those on WebEx, we're sort of in a tiny little box. So I think it'd be helpful if everybody here at least introduce themselves and we can see everybody's names on the WebEx. So I don't think we need to go through the mute, unmute process there unless people want to. Let's start with Mark.
All right, good afternoon, everyone. I'm Mark Millspaw. I'm the Director for Social Services in Baltimore County.
My name is Roz Berkowitz. I am Vice President of the Baltimore County Commission for Women.
Hi, good afternoon. Juliana Valencia Banks, Chief of Immigrant Affairs.
Alicia Begoff, Deputy Director at HANA.
Kelly.
Oh, Ellen Valley, Executive Secretary. Under the Police Accountability.
Hey, everyone. I'm Chanello Sockway with BC Stat. I'm also.
Everybody, good afternoon. Councilman Young, representative District 1 and member of the Baltimore County Council.
Good afternoon. I'm Rob McCullough, Chief of Police.
Amy Blank, Baltimore County Commission for Women.
I'm Shelley Hedelman, Senator from District 11.
Kanisha Stokes, Program Manager of the Baltimore County Office of Turnaround.
Anthony Davis, I am the interim Title IX coordinator at Towson University.
Andy Reynolds, Director for the County Executive's Office of Community Engagement.
And I'm Senior Policy Advisor for Education.
All right. And, Officer Kelly.
Officer Darren Kelly, Franklin, there's, domestic violence over here.
Great. All right. And I want to thank again all of those on, we know we have Delegate White Holland, we have Shelby Frick, we have a whole lot of people here joining us today. And it's really great to see so many folks returning after the first couple meetings. I'm glad we didn't scare anyone away yet. And hopefully it stays that way. All right. With that in mind now, I want to turn it over to Officer Kelly, if you want to join me up here at the front. And this is a topic that was flagged at our last meeting, and Councilman Young emphasized as well the need to go over the protective order and the peace order process and look at ways that that potentially can be improved in Baltimore County, particularly with the complainants in mind, the victims and survivors as well. So Officer Kelly's provided a presentation that I'm going to share on the screen, and we will hop into that right now. I know there's some flashing lights and animations, so it's got all the bells and whistles. And off and over to you.
Thank you. Do you have sound on this?
We do. I don't think we have sound on the, I think it'll cause some issues if we turn on the sound on this with that, but if you just want to, you can narrate, I'm confident.
I got the music in the background, so
Okay.
Good afternoon. Again, my name is Officer Kelly with the Baltimore County Police Department, and we are going to be discussing the protective order process as it pertains to how to get one, what one is, how long they're in effect to, and enforcement of those orders for victims of domestic violence.
Let me go to the next slide without freezing.
But just hit space.
All right, well, it crashed for me, so we are. Uh-oh. All right, I'm just going to manually go to the next slide because otherwise it's going to have a slow.
All right, so in this PowerPoint, we're going to talk about protective orders, eligibility and terminology, protective order services, as far as it pertains to removal of children, firearms, and the VINE program, legal representation for protective orders, which is the PORT program here in Towson, sub program, which is over at Northwest Hospital, HANA, and protective order violations and what are the arrestable offenses. Just to give you an overview of stats for domestic violence, last year, 2023, in the county, we handled 3,020 assaults between domestic abuse couples. Domestic couples we define as the department as married, formerly married, child in common, or live together as sexual partners, or have lived together as sexual partners. Now, we also investigate a lot of assault second degrees that are not titled domestic abuses, but are boyfriend, girlfriend, or girlfriend, girlfriend, boyfriend, boyfriend. Domestic incident reports, their arguments, what we like to document. I think it's good that we document as the police department because it gives an overview of what's going on within the relationship. So when you do have some of your assaults, it kind of gives you a bigger picture or a broad picture of what's going on in that relationship. And it's broken down by precincts on the assaults. So protective order served. We served 3,548 last year here in the county. That's the ones we served. There's probably triple that on what we didn't serve. Not answered, not at home, different locations, bad addresses. And we had out of that 3,548, we had 430 violations.
See that percent level. Stay the show. Good. Well, yeah, it was crashing.
Oh, was it?
Yeah, yeah. And it's partially just because of the delay with WebEx.
Gotcha.
Can we ask you questions in between, or would you
Yes,
rather
ma'am.
we wait? until
If you
the
got
end?
questions, ask afterward.
Does a victim potentially know that a PO hasn't been served?
Yes, so there's what's called the VINE program. So we will notify them if they register for VINE, to let them know that it has been served. Sometimes the officers will call them and say, hey, look, just so you know, we did serve him. And some of the, most of the petitioners in these cases are at the residence, so they're there when we're serving them and vacating them.
But I'm saying when they're not served, do you tell them?
No, we did not. So it goes back to the court. And then the court will have to, they'll go down to the court and they'll ask the court for an extension.
And then how do you register for the VINE program?
So if you, there's a pamphlet that we give out in our victim pamphlets that has the VINE program information in there, and you can register for it that way.
Is it all online or is it on telephone?
It is online. You can do it, register online or register by telephone.
When you, sorry, and is that pamphlet available in other languages? And could we get a sample of it?
I believe it's in Spanish. I don't think it's in any other language other than English and Spanish.
Could we get one sent to us?
Sure.
Thank you.
And would you say most do sign up for it or most do not?
Do not.
Interesting.
I will say also that as they are in touch with the domestic violence program, I'm seeing you nod, so I'm gonna say it for the 4 programs that it's pretty much part of our routine processes that we're gonna encourage people to sign up for VINE through phone or everything.
And Rebecca Allen just shared the link, I believe, to sign up, which is in the chat here, and I'll make sure we'll include that in the meeting notes from today, so that'll be included in what everyone gets when we circulate those as well.
And we also assist them with filling up, signing up as well.
Yes, sir. We're gonna at some point go through the process from you as a police officer or as the department receiving a need to issue a piece, issue it to someone. That process for you and who's responsible, and then when it doesn't get served over a certain period of time, how that's accountable or how that's held accountable. Okay, got it.
And if I don't cover it when we get to it, just let me know what you're looking for. Just to give you a little bio on myself, I've been with the department for 30 years now. Started in January of 1994. Upon graduating the academy, I've been assigned to the Garrison, which is now the Franklin precinct. And I've been the DDC there since the fall of 2000. Just to give you an idea of what the role of the domestic violence coordinator is, the domestic violence coordinator assists victims of domestic violence. We're a resource for them. We're a resource for patrol officers handling cases, specialized units. Our daily duties include follow up on every domestic abuse report written. Some of them are high dangers from the lethality assessments program, so we'll definitely follow up on them with our partners and our TV advocate partners. Arrest cases, and we will schedule home visits with our TV advocates to go into the home and talk with the victims. We also do every protective order, whether it's a violation, if the order was served, the temporary order was served, and there was firearms taken from the respondent, we'll keep track of that just to see what we're to do with the firearms after the hearing. Whether it's if the order was dismissed, then we'll run a background check on the respondent to make sure he's eligible or she's eligible to get their firearm back. And then we'll keep track on them when they come as if there's a final protective order. The court mails them to our central records then distributes it to the appropriate precinct, and then we'll follow up to make sure the respondent's in compliance with the firearms restrictions. And answer any questions they have. So we also do DV case enhancement for the state attorney's office. And we also do education on DVs with our officers, and I do the recruit classes as they come in. And also, we work with our partnerships and the state attorney's office and our DV advocates. So protective orders 101. So I know most of you in this room are probably familiar with domestic or protective orders and what they are, but for those who are not, a protective order is a domestic violence protective order. It's a civil order that protects a victim of domestic abuse, a victim of recent sexual assault or attempted sexual assault committed by anyone, a wrongful result from abuse, or any person regardless of the relationship, or a child who was sexually abused by anyone or physically or mentally injured by a parent, family, or household member, caretaker, or others. So who's eligible for a protective order? They're married, divorced, currently separated, have lived together, a sexual relationship for the last 90 days, the past year, have had a sexual relationship with each other in the past year, were raped or sexually assaulted by the other person, including attempts in the past 6 months, are the parents of the child together, are related by marriage, blood adoption. This includes step parents, stepchildren, if they have lived together for the last 90 days in the past year, or they are a vulnerable adult. So what is an abusive act? Before the court can grant a final protective order, the petitioner must prove that the respondent committed the following acts of abuse, which includes assault, which is your misdemeanors and your felonies. Your misdemeanor assaults are your pushing, your slapping, punching, kicking, mushing. Your felony assaults can be with a handgun, weapon, knife, or strangulation. It's also an act that places the person in fear of imminent serious bodily harm, an act that causes serious bodily harm, rape or sexual offense, or attempted rape or sex offense, stalking, false imprisonment, or revenge porn. Revenge porn is basically falls under the harassment. If the suspect posts videos of the victim online, that is revenge porn. So what is a petitioner? The petitioner is the one who asks the court for relief against the abuser. They are the protected person in the order. A petitioner cannot be charged with violating their own order. Why would you say that? Well, sometimes when we handle domestics, it's different than any other crime we handle because there's a relationship between the two. Sometimes they'll reconcile and be back together even though the order's still in place. And the petitioner might even have them over there, and then next thing you know, an argument starts. So we respond when we run them over there and dispatch advises that it's still active protective order, even though the petitioner asked them over, the petitioner cannot be charged, and only the respondent can. If that's the case, then they can have it rescinded. So who's the respondent? The respondent is the defendant in these cases. They're the one who is alleged to abuse the petitioner, the one who the court has ordered from further actions against the petitioner, and just note that these orders must be served on them first before the respondent can be charged with a violation. These respondents, especially some of the ones that have been through it time and time before, they will duck service a lot, and it's hard for some of these victims to get the respondent started. They've been through the process before. So there's 3 phases of the protective order. The interim protective order. The interim protective order is an order protecting from abuse issued by the district court commissioner when the district court is closed, and they are valid for 2 days or at the end of the second business day. Temporary protective orders. Temporary protective orders is an order of protection of abuse issued by the judge and lasts for 6 months for service. Temporary protective order is based upon the petitioner's application of abuse. And if the respondent appears, they can have the hearing right there at the temporary hearing. And it's based upon the testimony from both the petitioner and the respondent. And of course, the final protective order is an order that is issued by the judge after hearing both testimonies from the respondent and the petitioner. After presenting their evidence and testimony in a full court hearing, the judge believes that the abuse has occurred, or if the abuser consents to it, the order will be issued. The order is considered served once it's issued that day. The interim protective order, the commissioner cannot issue the surrender of firearms. And the temporary order, the judge has the discretion in order to order the surrender of firearms. And if it's a final order, there is no discretion. It is mandatory that the respondent surrender their firearms. What the petitioner needs to do is go online. They can actually download the forms on the court, and there are the forms up there. And basically, it's just fill in the blocks and tell the court exactly what happened. The ones on the left, that's the main petition. The one on the right, that's the addendum. And then there's another one where the petitioner can request that their information be shielded. So if they move out of the abusive home and they move into somewhere else, they can actually request that it be kept from the respondent so they don't know where their address is. So there's a new House bill that took effect in 2022. Basically allows petitioners in a temporary hearing only at this point to have a video Zoom meeting hearing with the judge. But it has to be from an approved either a hospital or domestic violence advocacy group or sexual assault program, prevention program. It has to be pre-approved by them. That started in October, I haven't seen too many of those. I haven't seen any actually. But hopefully, they're there, they're there for a reason. That meeting will, or that hearing will take place that day. This is weird. Everything's based on the
Sound.
sound and motion.
That's okay.
Get back to the previous one. So I got stuff under there. So basically, when the order comes into the precinct, it's relayed up to the precinct that in which the respondent resides. The desk officer will receive it. The desk officer runs a complete background check on the respondent, and that background check includes open warrants, criminal background, history with law enforcement, and firearm checks. The firearm checks are done through FS00, and there's a new one now. We actually got to send it up to the Maryland Gun Center as well. So once all those checks are done, then it's then added to and assigned to the postcard. Postcard will make multiple attempts for service. They will indicate on there on the forms the service attempts. And then once it's served, it's taken back to the desk. The desk officer enters it into bind. Bind notifies that we have to do it within 2 hours of service. And then bind will notify the victim that it has been served. So that's doesn't hurt just to give the victim a call, or the petitioner a call, say, hey, it's been served.
How often, like, what's the standard time frame for if an officer goes out to the address, the respondent's not there? Is there a time frame by which they go out again to try to do service?
Yep. So obviously we're 24/7. We as the police department do service on the day shift and evening shift. So from 6 o'clock in the morning till 10, usually 9, 10 o'clock at night, we do service. Now, if there's a call for service on the midnight shift, or the order needs to be served, obviously they'll serve it, or if the respondent's arrested for something else, they'll serve it while he or she is at the station. But once it's served, there's a return of service that goes to the court. And then the court will obviously have record of it being served. Once it's served, we document it that we serve the order. That way, if there's a violation later, on down the road, the officer can see that it's been served. We check the database. If the order is not served, so what happens if the order is not served? After the court date, the schedule is issued today, and the hearing's on Monday. Monday comes, and when we haven't had them served yet, it just gets returned to the court unserved. We fill out the paperwork unserved. It gets returned to the court. Now, at that point, the petitioner has the choice to ask the judge for an extension. Judge can extend it again up to 6 months for service. If the judge decides that there's enough probable cause to believe that there's reason and probable cause to extend it, then they will, and they usually do. So we'll get the same order back, and we'll continue to make attempts.
So is it like, and I don't mean to belabor it, but is there a policy where if you go out and they're not served, try again the next day, or is there any sort of?
Still served.
Okay, but like every 24 hours or?
Yeah, so it gets assigned. So every morning we have roll call. Roll call, the orders are distributed by the supervisors to the patrol car, along with warrants and summonses. So, and their course of duty between answering calls for service, they will make attempts. Once those attempts are made, it's attempted until served. If not, it's passed on to the next shift. The next shift does it. So let's say we get it Monday, and the hearing's on Friday, we will continue every day until service or the court date arrives.
Okay.
Yes, sir.
Those numbers that you showed earlier on about the precincts and the number of, forgive me if I'm misunderstanding, like one precinct had 405. Those were just calls. Those weren't necessarily associated with protective orders.
No, the first screen of stats, that was assaults, just to give you an idea of what the victims are going through as far as assaults and what the volume of those are. The next screen was protective orders.
And those are ones that were served, not ones
The
that.
3,000 were served. The ones by precinct were violations of those orders.
So, sorry, the ones that are served are obviously reported. The ones that are just consistently either rotated through, or ones that even, the person waits out the respondent.
The respondent waits out the expiration,
And then they can't make or then the petitioner can't make the date and eventually just drops it because it's not providing service. Is there a record of those? We have a record of all the ones that are being requested, but
There
not.
is no police report written documenting non-service, other than there's a logbook, every precinct has a logbook, and in those logbooks, it's all handwritten, believe it or not, today, we still handwrite stuff. And it gets logged in as not served, that's the only record we have of non-service.
What about from the court?
I can't speak.
No, you're right, I'm not trying to put more on it then.
There is. So like, not that there's been attempts, but what will happen is the petitioner will come. If it's not served, they can sign what's called a waiver where they will say like, please keep on trying to serve this and extend it and let me know when it is served. And the judge can accept that waiver for up to 6 months. So if it reaches that 6-month point and it still hasn't been served, then it can be dismissed, but it's that, so there's gonna be records of that,
Yeah.
but and records of the waiver, but not the continual attempts.
Fair, and I'm not trying to, and I appreciate the information, like, this is exactly why we brought up. I'm trying to get an accurate picture of what we're serving, and then what also we're hearing from folks, not, folks that are representing, and also ones, the petitioners that are not receiving what they need. What's the ratio of folks that are actually being served versus the number that's eventually just being given up on because it's not providing what they were expecting, whether that's numbers through the court because they're keeping track of that, because they keep showing up, but eventually what inevitably happens, what I understand is what's happening, they wait them out to the point, maybe they've gone for 6 months straight, they keep going up, keep ending it, but then they're still not being served, so then they just throw their hands up at it, don't show up the next one, it's not extended. So I'm trying to get the accurate number of what's being served versus what's being forgotten, whether through attrition or just lack of actual service being provided to the petitioner that's trying to receive protection, protected from the board. Am I making sense there? You're trying to get an accurate picture of what's being dropped, not by anybody's fault, but just from the perspective of the land.
As far as on our end, nothing's ever dropped.
You're right.
But because it's always returned to the court, but we don't reflect that in a report being written saying we didn't make the service and write a report on it.
Right.
We only document it in a report if it's written and served.
Right, and that makes sense, they do, yeah.
And then it's just returned to the court, and then the court would have record that it wasn't served.
But you said a minute ago, when you were going through those numbers, that that 3548 POs served, you said triple weren't served. So you're serving a third of the ones that are.
I'm saying that's my opinion, that
Yeah.
it is probably triple that number on what we don't serve.
Okay.
But that's just my opinion, double or triple.
Yeah, we still keep a cover sheet on those.
Yes.
Right, so that also serves as a departmental
Yep.
form for us for tracking.
So we have two cover sheets. One's a departmental form, one we made to help with firearms, and make sure that it's taken care of. Those forms are kept in the precinct, but they're not in a computer database. And they're only come up for about a year or two, and then they're shredded. Because at that point, if it's not served, there's no reason to keep all this papers, especially when the court, if the order was issued and say it's good for a year, it already expired. And we already have record that it was served anyways.
Yeah,
So is.
word comment.
Yeah, it's kind of moving forward just a little bit. Do we have any like information on whether some of these are like repeat offenders or?
Are they? Or other than looking in the database to know that they're repeat offenders, and each DVC should know who the repeat couples are and who they deal with on some of them maybe once, twice a year, some of them multiple times a year that we deal with. So yes, we do know who our repeat offenders are, and you can see just by, let's say if it's a patrol officer, they can look it up in the database to see if there's a history of domestics or what their service is.
Thank you.
Yes, ma'am.
So so current law states that they can only be served in person, correct?
In person, we've had some that won't come to the door, but we know they're in there. It's on your door and we know it's them. You can see them in the window. We have their picture. So yes, in person.
And have we ever considered other options for trying to serve individuals? I'm seeing distinguished senator shaking their head.
Oh, I don't know. That's an interesting question.
Yeah, I mean, I'm wondering.
I've heard of petitioners I haven't seen it, but I've heard of them actually hiring process servers to serve them themselves just because they, police have tried from time to time again and they've been ducking us. But, I have heard them using process servers. Other than that, I haven't heard anything else.
So,
Other than the circuit court, if it's circuit court order, then the sheriff's department serves.
so would we need legislation if we were to look at other technological ways in which we can serve individuals? Because 2/3 of the individuals we're attempting to serve, we never reach, correct? Roughly.
Of those 2/3, some of them are the ones we serve, but are also previous respondents in cases. So, yeah, I mean, there's a lot that we don't get to, and it's not from lack of trying, but it's just that they're not gonna. If you can come up with a different means, especially electronically, I'm for it. And everyone has a cell phone nowadays, but
The only problem there is still, even if you send it to them electronically, how do you prove that they actually received it, and how do you get them to accept it?
that's why it's always been in person all these years. So, but if you can come up with something great, that's great.
Yeah, and Darren, I know, I'm sorry.
Technologically, we could figure that out.
And Darren, I know you guys have been creative also in your efforts in terms of some of the things that you guys do to try to track these people down and serve them too. So.
Yep. So especially if they've been arrested, sometimes they'll put their cell phones in different addresses and when they register. So sometimes the petitioner might not know where they went, but in the records somewhere and background checks will pop up where they're residing at now. So then we'll either make sure that it could be in a whole different jurisdiction, and we'll make sure that jurisdiction gets relayed the protective order for service.
In a past life, I represented a lot of petitioners, and we use a lot of prior process servers just to keep the process moving and feel at least somewhat. I know one of the concerns, just speaking anecdotally, is the feeling of control over the process was a concern for a lot of petitioners. They wanted to feel as if, okay, we know when the process server is going out, I can tell my attorney, in this case me, where they work, where they frequent, if they're going to duck service, or if they post incident where they have a feeling that the victim may go to the courts, that they leave and they go to a hotel where that may be. So I know that was a concern, is the feeling of control and specificity about where to serve. So,
and we do get 911 calls from petitioners saying, hey, person's home, such and such person's home, or such and such person's at work, which is helps us out for service.
sure.
So you've had
Okay, from Rebecca, there's a grant program through GoCap that provides law enforcement with resources to meet district and circuit court guidelines for efficient and timely service of POs, reducing and minimizing the time between the issuance of the ex partes and Kelly, if you want to pull it for us. You click on it, it'll if you click on the chat box, there you go. All right, we'll make sure that after we get out of the presentation that's the full comments shown.
And if they've had to ask for an extension because it wasn't served, is the victim then allowed to pay for a process server and have the process server meet with you too?
They generally don't meet with us. They'll just get served on.
Or just,
Yep.
so the victim can do that themselves?
Yep.
If
I've seen, I've heard of cases. I haven't seen them personally in any of my cases.
I'm curious.
I know for us, it's always a sticky issue because there's always been that argument of accountability on our part to make sure that we're tracking them and that we're making sure that we're not only serving them, but also making notification, to the people involved that it's been served.
This was a nice little SWAT one. So, reference, this is from our rules and regs. If the order requires the respondent to surrender firearms and they refuse, that is an immediate arrest. We'll basically hold the house, and then if the petitioner is legal access to the residence, we'll get consent. If the petitioner doesn't have legal residence or legal claim to the residence, we'll hold the house and obtain a search warrant for the firearms based upon the information that we receive. And our IST and our gun squad handle those. So, and we're gonna get into what's arrestable, because not everything in a protective order is arrestable. Just real quick, just wanted to touch on the assistance request. We do get a lot of these, mainly from the respondents. We'll say, hey, we might serve them at their place of employment. We'll tell them, you know, call 911, don't go to the house. Ask, have a copy of your order with you, and make sure it states in there, the officers to make sure it states in there that they're allowed to go back, because a lot of the orders actually state in there. They may return to the residence to retrieve personal items with the company of law enforcement. They can't not go back once they've been served. So the officer will get out and to make sure that is in there. If it's not in there, they can't go back. If it isn't in there, we'll send them back down to the court, the respondents back down to the court to get that added in there. Reason we do these and we do document these as under the domestic incidents is because the respondents will abuse that from shift to shift. They'll call in, hey, I need to get my stuff. So they'll call in, we'll go out and get it. They'll call in later again, hey, I need to go back and get more stuff. Well, to me, that's just keeps traumatizing the victims over and over again. So if it's documented, no, you had your opportunity to get your stuff. Your stuff includes your clothes, medicines, work stuff. That's it. We're not moving TVs, couches, and everything else out. So, and I always have a time frame when they can. Look, I know we're asking somebody to move out of their house. A little compassionate, but we have to have a time frame, because if not, they'll. And the court actually changed that. They used to have between 9 and 12. And the respondents would put, oh, I'm allowed to be here from 9 to 12. No. So they changed it and made it at the discretion of law enforcement. So that way we can get in, get their stuff and get out. Circuit court orders are served by the sheriff's department. They obviously don't have interim, not my aware of, but interim circuit court, but they have temporary circuit court orders and final court circuit court orders. If the victim goes up to the circuit court and obtains a circuit court order, they are served by the sheriff's department. The only thing the sheriff's department do is when they serve them, they can't collect the firearms, so they'll call us and we'll come out and take the firearms. This is the hardest one for me, is removal of a child. So when we see the interim and temporary orders, especially temporary orders, whether it's a removal of the child, we review all the orders, but if it's removal of the child, while the order may stipulate the child may be removed from the home, the order does not authorize us to use force to get into the dwelling. So a lot of these, the petitioner might reside somewhere else and have a separation from their other partner, but the children might be at the respondent's home. We cannot forcibly remove those children from this home. However, we will check on the well-being to make sure they're fine and try to use verbal skills to say, hey, at least bring them to the door, to the window. Let me check on them, make sure they're fine. If they're fine and they're refusing to give them up, that is a contempt violation. It's not one of the arrestable offenses. We'll send the petitioner back down to the court to talk to the judge and see if they file a contempt violation. Yep. So we always want to make sure you know the one on the right, and anyone know the one on the right.
Gonzalez.
Yep, that was the Ilian Gonzalez. They went in and basically removed him by force. We don't want that because we don't want to, obviously don't want to traumatize the child. And more than anything, the one on the left is more desirable. We do out of state protective orders, not that much, but we do get them. And the next slide, there are multiple things within the slide, but I can't show you. But if an out of state protective order is issued, let's say in Pennsylvania, and the petitioner moves down here to Maryland, and there's a violation, we will enforce the violation. If it's an arrestable offense in Maryland, then we'll enforce it as an arrestable. If it's an arrestable offense in Pennsylvania but not in Maryland, we will only treat that as a contempt violation, so they'll have to go back to the issuing court. Now we do take full faith and credit that these orders are valid. We still verify them though through the issuing agency. This is a big one for victims, especially if they haven't been through the process. It's protective order representation. In my safety package, I issued 2 of these, in every packet. One's for Northwest Hospital's DUB program. Ellen Harris, everyone knows Ellen. Ellen's been doing it for a long time, and she's very good at it. She will represent the victims of domestic violence in the protective order hearing, and the same as the PORT program. If the victim chooses to use the PORT program, that goes through the circuit court. Again, the sheriff's department will serve them, but we do hand out that information as well. I think it's a great resource for victims, especially if they haven't been through the process of protective orders, because it represents them in court. So warrantless arrest, we as a police officer shall arrest with or without a warrant and take into custody a person the officer has probable cause to believe is in violation of the protective order. The following court order restrictions are the only arrestable offenses in a protective order that the respondent will be arrested for. So abusing or threatening the petitioner, contacting or attempting to contact or harass the petitioner, refusing to vacate the residence when required by the protective order, entering the petitioner's residence, failing to stay away from the petitioner's or other family members' place of employment, school, or temporary residence, or failure to surrender the firearms. They are the only 6 things that a respondent can be arrested for in a protective order. Everything else is a consent violation. Yes, sir.
But obviously, only after that they've been served.
Correct.
Right. So-
Yep. So once the respondent's been served, some of these orders, there's a few of them. They'll issue, let's say, and a lot of it's at the request of the petitioner, where the petitioner don't want them out, they just don't want to abuse them anymore. So it's not a vacate, but, so we'll get a domestic incident argument or a domestic argument call and we'll respond. Well, that's in effect and they threaten them, so, sorry. Based upon, we'll get a written statement from the petitioner and then we'll end up arresting the respondent. Yes, ma'am.
This applies to all types of protective orders, like the temporary, interim, and the final ones, or just final?
So the temporary and finals, definitely. The interims are limited, especially when it comes to firearms, which is weird. So an interim protective order, the commissioner can't issue the removal of firearms, but in an interim ERPO order, they can. It's weird. Yes. So most of them can do the same, except, again, when it comes to firearms, judge's discretion in the temporary and it's mandatory in the final.
And Officer, or Krista Tran has a good question, are you comfortable with this PowerPoint being shared?
Yes.
Okay, great. So we'll make sure it's available for members of the working group.
If the respondent violates any other provision listed, they are civil infractions, which we as an officer cannot take enforcement action, like an arrest. In those circumstances, it's still a violation of protective order. We'll document it as such, but in that case, we'll have to send the petitioner back down to the issuing court, to the clerk's office and file a contempt violation. And again, it is mandatory for an officer to arrest with or without a warrant if the officer has probable cause to believe that there's a violation of the arrestable conditions of the protective order. And just a reminder, petitioner cannot violate his or her order. He cannot be arrested. Your Spicer special. Massage here. You can see the helicopter fly by. Violations of protective orders, the officer responding will review the order and formulate a response to the complaint and determine if arrest can be made. They'll contact our central records to verify the protective order is still available or still active. There's other ways to do that as well. If the protective order cannot be verified, the responding officer will go over safety planning with the victim and do some other departmental things. But in today's age, it's really hard not to get a copy of an order. I mean, they're everywhere. I mean, with internet faxing and secure faxing, it's pretty easy to get copies of orders. If the investigating officer again has been verified that the order is active and the respondent who violated the order is no longer at the location, the investigating officer will apply for a warrant summons. That is a departmental rule and reg requirement that if you have a respondent who has violated the order and was at present, we will go down and charge the respondent for the petitioner. And if you are responding in a protective order, you cannot give your firearms to someone else to hold. We have additional strategies that we use. Again, our advocates are very important to us, the victims. My advocate is Cassie Offit from Northwest Hospital. She's been doing it for a long time. Unfortunately, she's been stuck with me for the last 15 years. So
She loves it.
they do safety planning for victims. We can do other things. We just put a postcard alert out the other day to the precinct, basically identifying that the victims, our advocate actually called over, was concerned in reference to this case. So we put together information pertaining to the suspect, to the vehicle, and to the protective order. That way, if they get a call there, they'll have all the information available to them. Some of our other resources are Warrant Apprehension Task Force, and in this case, with the postcard alert, he actually had an active warrant, and we called them, that got him there next morning. So got him, he got no bail, was held for a while, and was on home detention. So we'll work on that. Hopefully, he'll abide by the protective order, but if not, we'll deal with it then. Another resource is our firearms interdiction team. They're great, especially because now it's a final protective order to prove that in person. Any questions about protective orders? Yes, ma'am. No, don't apologize.
So back to the firearm piece. When you're doing the firearm removal, is that only for firearms registered to that person, or, you know, if both parties live in that, you know?
So if the petitioner has firearms and the respondent has firearms, we only remove the respondent's firearms because they are the ones. Now, if the petitioner says, hey, you take mine too, we'll hold them for safekeeping. But usually, I haven't seen a whole lot of those cases where that happens. If they do, the petitioner himself will remove their own firearms. And firearms include rifles, shotguns, everything else. So we take them on for safekeeping.
Does that include any unregistered or ghost guns?
Yes. Anything.
Any
Any firearm.
That'd be a whole other issue too, if they had unregistered guns in the house when you.
That's why it's great that we use our other resources like the firearms interdiction team. That's their bailiwick. That's what they deal with. So it's good to give them a holler. Just couple quick things on peace orders. There are civil orders again, ordering from one person committing certain acts against others. Only the district court is the only one that has jurisdiction concerning peace orders. Circuit court does not. Who is eligible?
Yeah, I have a question going back to the firearms. Does that include, let's say a sibling has a gun, do you also take the sibling's gun or just?
So when we go in for these, we have to determine if they have access to those firearms. Especially when we're doing our ERPO cases. Are you familiar with ERPOs? Extremist protective orders. That's a whole different thing. That's a whole different touchy subject, but only 19 states have them. Maryland's one of them. And in those type cases, if, like, say, a sibling has a firearm, are those firearms secure, and does the respondent have access to those firearms? So we take all that into consideration. If in, especially in the ERPO's cases, if they do, then we'll take those guns for safekeeping. You're welcome. So who's eligible to obtain a peace order? A petitioner can obtain a peace order against the respondent if they're not eligible to obtain a protective order. They're your neighbors, acquaintances, strangers, coworkers. A few years ago, it changed where they added employers can apply for peace orders. And basically, an employer can file a petition for a peace order on behalf of an employee based upon certain threats of acts of violence against the employee in the employer's workplace. And in that type of situation, the employer is the petitioner, and the employee is the on behalf of party in the protective order. The employer must notify the employee before filing a petition for peace order on their behalf. The employer cannot retaliate against their employee for not providing information against or testifying in those proceedings.
So, for instance, a school, could a school get a peace order if they?
Against the parent, say, disorderly parent?
Well, I'm just thinking sadly about situations that have happened at schools. And I'm wondering, to protect a school when a family is in a situation like this, would a peace order be applicable to a situation like that?
It could be, depending on the threat by the family. If the family's a danger, then maybe, because again, ERPO's a lot different. ERPO's a police officer can be a petitioner. So that makes it a little bit more encompassing to handle those type situations. But peace orders, I wouldn't see why a school wouldn't. I mean, it's still technically a workplace. Sure.
I guess piggybacking off that for clarification too, in a school setting with, and if I'm getting at it, it's two juveniles and they're in a relationship and there's abuse between the two of them, that would fall into a protective order if it went to that. Like outside of the school.
But the parent would have to be the petitioners, and that's like case for their son or daughter.
Right. But that would be in that scenario.
And that's juvenile court. That's something different. And a lot of times in the juvenile system, they'll use can't think of the words. They'll kind of negotiate between the two parties. Mediation, yes, like that.
And not to get too far abreast from what we're discussing here, but then if there was like a bullying situation, but there's not a relationship, it would be the parents still, and they would be filing a peace order because it's not a relationship.
I haven't seen so many of them, but they could, yes. A lot of times the schools deal with them, and especially having SROs in the school, it helps out a lot too. The SRO can kind of be the peace order.
We definitely jumped to because I was thinking students, but there's multiple parents are going.
And again, we do it where the juveniles making threats on social media. We do deal with those too. And again, if that's the case and the juveniles has a firearm in his possession, then they're already prohibited to begin with because they're in possession of a firearm.
Right.
But then ERPOs are designated for juveniles. So,
thank you.
So since these orders are only, I think the longest they can be are only
6 months.
right?
Yep.
So can ERPOs extend that amount of time or?
ERPOs run along the lines of a protective order. They're good for a year. Peace orders are good for 6 months. Now, peace order can be extended, and we're going to get into that. They can be extended with a show cause hearing. You can ask the court to extend the peace order, but not for more than 6 months. Peace order must be filed by the petitioner within a 30-day of certain specified acts. There is an application fee and a service fee. The court may waive the application fee. Protective orders do not have one. Acts committed by respondent against the petitioner for eligibility. Act that causes serious bodily harm. An act that places the petitioner in fear of imminent serious bodily harm. Assault in any degree, false imprisonment, harassment, stalking, trespassing, malicious destruction of property. A few years ago, they actually removed sexual assault and moved that over to protective order. This is real quick what an interim protective order is, or a peace order, sorry. When the district court is closed, same thing, petitioner may file a petition for a peace order to district court, commissioner's office. Commissioner's offices are available 24/7. They're usually Essex, Towson, and Catonsville. The interim peace order will expire at the end of the second business day. The district court is closed that day. The next day, the district court is open. Temporaries are retained by petitioners during normal business hours of the court Monday through Friday, 8:30 to 4:30. The temporary peace order shall remain in effect not more than 7 days after law enforcement has given the respondent a copy. Usually the hearing is scheduled within that time period. If the court is closed, the day the order is due is expired, the order will remain in effect until the second day in which the court is open. The judge may extend the order as needed up to 30 days, as opposed to the protective order. The judge could extend it to 6 months for service. Peace order, the judge extends them for 30 days. Final peace orders, the final peace order shall be effective for a period of not to exceed 6 months. A petitioner may request the peace order to be extended after a hearing of a good cause is shown. The court may extend the length of the peace order by 6 months. The following are the arrestable offenses and a peace order, which they will be arrested for by law enforcement, refrain from committing or threatening to commit any of the specified acts against petitioner, refrain from contacting petitioner, refrain from entering the residence of the petitioner, remain away from the place of employment, school, temporary residence of the petitioner. If the respondent violates any other provisions not listed, it's the same thing. It's still a violation, however, it's a contempt violation. The officer will still take the report and then we'll send the petitioner back down to the issuing court clerk's office to file a contempt. Any questions? Yes, ma'am.
That's a lot.
It is a lot. And we start throwing herbos and a lot of other things. Peace orders don't cover firearms. Generally, 99.9% don't cover. We had one judge issue a surrender of a rifle. All legal, he said, if it's in the order, take it. So we ended up having the respondent surrender the firearm. That was
So
years ago.
with everything currently in meaning policies, programs, procedures, what do you think's working well and what do you think could use some improvement? Or are there areas in which legislation or support from a group like ours could provide in order for you to be even more successful in the good work that you already do?
Well, that's a tough one. I'll leave that to the boss.
Yeah.
Good answer.
Come back to the boss.
Sorry.
I've been dealing with this almost 40 years of my life. It's very complex. I think we do a fine job. I think from a management perspective for me is to making sure that we do it in time, efficient, and effective manner. And I think we've gotten that down pretty much to a science in terms of accountability. Making sure that we have the resources and everything. In terms of legislation, for the most part, everything works the way it's supposed to work. And then the place where we really saw problems were like when you had two different people going and getting, orders and then kind of figuring out how to enforce that and deal with that. And I think, for the members that sit on the CJCC, I think over the years, we've kind of brought clarity to that. We continue to work on that. So. That's the best way I can kind of frame it for you. So I don't see.
So I mean, this isn't a policy answer, but in terms of practice, I heard you say, Officer Kelly, numerous times, the role of the court advocates in this. Can you touch on that a little bit? Because I do think that assistance in navigating and being supported through this process is pretty huge, but it's a resource issue. So,
And like everything, like I said, we use the FOR program and DUB program for our resources to assist victims or petitioners. Like everything else though, it's, you can't force somebody to use that service.
are you speaking solely from the Wilkins precinct perspective though?
Garrison.
I know the answer. I mean, Garrison, sorry.
Franklin.
Franklin. I know I already know the answer to this, but are you speaking from that perspective only?
Yeah.
Right. So what are we doing about that, having the capacity to do that?
So we try to, when we go out to trainings, we pass out flyers for the FOR program, for DUB program. We include in our safety packets when we do our safety home visits with our victims. The information, I think, is getting the information is the key. The problem is if that person's willing to stop going through the abuse and enduring abuse and trying to make that person realize it's not a healthy relationship. But
the data, I'm sorry, just the data on the first or second slide.
Go back to it.
You didn't have those in numerical order. If you look at them, right, there was a pretty sizable number in the Essex precinct,
Yeah.
Middle River, Dundalk.
they're our biggest data.
Right? That's where, no, keep going back, no, that's it. Yeah, right there.
And it's always been that way.
Right.
It's always been that way.
So, you know, I think
One that our number is down, Essex was in the 600s,
Yeah.
660, I think was their number in 2022. So they have come down a little bit, but again, of all those, how many are new cases and how many are repeat offenders?
So we have a breakdown of like age range for our most.
I don't have it, but I'm sure you could, I'll go in reports.
So I was also thinking there might be a way to also partner with, not that, just say if it showed like our college age, right, is something that we're really seeing, like adults, they're adults, but in college. And, you know, partnering with our colleges and our campuses to make sure that we really get this education out to them. And I know you guys do a bunch of different things to really get the word out, but I think having some more partnerships with some of these college campuses also is a good.
And we have done Stevenson talks with the nursing program, with domestic violence. We do get a few calls over there throughout the year for domestics.
So, you spoke on your precinct, and so Turnaround works with the DVCs of, of Cockeysville, Towson, and Parkville. So they go out, do home visits, do some of the things that you're referring, to that the Dove program does. And also speaking to universities, Turnaround has been in partnership with Towson. They are trying to get a lethality assessment protocol program over there. So we have an MOU floating around somewhere, waiting for someone to sign it. But hopefully that'll be coming soon.
Will that be the first?
I believe so. And how that came about is, I don't really know her title. I apologize. Please excuse me. But she was a DVC for Baltimore County. So she saw how important the lethality assessment was and the benefits it was for having it. So now as Towson is getting a new chief or recently got a new one over there, they're in communication about, so hopefully really soon we will have that at Towson.
And Shelby Frank from FCC noted that they're working with the colleges on their side as well. So
Also to piggyback on what Turnaround was saying, I'm sorry, I crashed.
It's fine, Kamisha.
Misha, that HANA also, so all of our programs have legal advocates for sure, but HANA, being a culturally responsive provider, we partner very closely with the Pikesville precinct as well. But I think it's important to note that in a post-pandemic world, I think all of us are like pre-pandemic. I think Baltimore County functioned almost like mini counties where lots of the programs had strong partnerships with UBCs in their areas. I think that still is absolutely happening. Like we definitely talk with Darren and with John in the Pikesville precinct, probably more so than the other DVCs. But I think all of us programs are serving everybody, and therefore we are all talking to all of the DVCs on a frequent basis. So I think it's like, it is important to focus on the outreach in the specific areas, but the partnerships and the resources I think are happening throughout.
I think if we have a scotoma, I think the one place that we probably to look for is at our immigrant population.
Town does have a huge move in Brooklyn.
Yeah, and well, the entire county, I mean, it's just growing and expanding across. And it's probably.
They're not monolithic because the American community is incredibly diverse, and what works in one community is not going to necessarily work with other ones.
So
do any of our, I know we partner with Adelante for certain services, but they're not providing any court advocacy. Worried about that?
So Adelante is a part of House of Ruth, and they have the legal clinic and court advocacy. So
That are partnering with our law enforcement though in Baltimore County? I think they do it in the city. I don't-
Mhm.
Yeah, probably not.
I don't know if we have
Yeah.
that here, so that is definitely.
And I think it's personnel, like we do have a Spanish speaking advocate, but one advocate in a small, in a, I don't want to say small, but one advocate in an agency does not serve a whole population. Like that
Right.
doesn't do the trick.
Yeah, and we've recently, actually, our advocate, who was our LAP advocate, she recently took on the position of, she's like our bilingual advocate now, so she works specifically with our immigration population. So we'll have a new LAP advocate, and does a lot of like the training on the culture and the differences and why it's such a challenge within turnaround, and hopefully she can do some more trainings in the community.
But there's probably a need to look at that more closely, consistently across
Absolutely.
all three of the advocate groups.
So I think we all, and I'm just going to say things I think we all know, data is important, obviously. And just being, so I mean, I look at these numbers, like everybody does, and start seeing, looking at the bigger ones and asking like, why are they bigger? And I'm sure we could have a separate meeting just about that and thinking of ideas. But I go back to the question I did ask earlier about being able to track, because we look at this and we start thinking about, as it's been like Wilkins, Woodlawn, what can be done in those communities or what's different about them. And then I, again, asked the question about the numbers of served respondents and the tracking of that data of actually served. The successes, I'm not, this isn't a criticism either. It's just a matter of process and being accountable for what you've been asked to be accountable for. I believe it's on paper. A lot of stuff in Baltimore County is on paper. Probably shouldn't be that way. It must be easier to track some things a little longer and easier if it wasn't on paper. I would be interested in those other numbers of not being served, and that information that we haven't captured. One, repeat offenders, and even if it's in the court or if we can have it, or in terms of a deliverable or something to ask for that doesn't necessarily require a policy change or like a legislative change. Is there willingness from the police department or willingness to work with the administration to hold on to that data more, or have a systematic way of recognizing that we are serving maybe 43, 43 out of how many? I think anecdotally you said in your opinion, no, it's a lot more. But I'd like to know how many it is. Is it 100 more? Is it 1,000 more? We're serving 43. Any number is as valid as something else because we're not tracking it. So, and in that number that's not being served, how many folks are repeat offenders? How many folks have been ducking for how long? How many folks don't speak English as a first language? That would then also tell us what service we need to request from the judiciary to provide the service.
How many orders do we serve that we do serve that don't go final because either the petitioner or FTA or request that the order be dismissed?
Exactly. So we have it's not just numbers, but informed numbers, so we can make seeing the field and being able to make an informed decision about answering that question. What could be done legislatively? But at the moment, even if it was just like, oh, well, we're only serving 43 versus 1,000. Well, that looks bad, but what's the details in there? And I'm interested in knowing that. I'm not sure how much willingness or ability there is for whether even trying to do it at the precinct level or countywide to capture that information.
Darren, let me ask
Yes,
you.
ma'am. Good.
Yeah.
Good. I'm glad to say it, but also.
Part of our goal with BCSAT and my colleague Lindsay is on mine is to be able to figure out where are those discrepancies. And after this, I'm probably going to touch base with you so that we can get that data and kind of take a look at what does the big picture look like.
Sitting next to it.
Darren, how labor intensive would it be? I know you guys do a monthly report, so how labor intensive would it be to add that to a monthly report or to track that data?
Served or unserved? Served
both? Both.
To serve would be easier. Unserved, I think, spitballing, the only way I think you could really get back and unserved is go back to that logbook and that's if the logbook's updated. So you would have to go back and track. Sometimes you have to go back to the computer to track. Okay, well, this order was issued, what happened to, it's not served. And then it can be done, it's just gonna be very.
And that's the question too about
Can't
what's
get that through the court.
willing.
You don't have to report back to the court what was served and not served.
We do. So on the forms, on every protective order, every peace order, every group we get is a service form. And it has on there whether we served it or whether we didn't serve it. Either way, it goes back to the court, either served or unserved, right?
You might,
Are you
PC
asking
staff may
how
want
many
to start
forms?
there.
That might be a way to track the unserved ones.
Right, so if we copy those forms rather than before you send them back, whether it's the BBC or the admin officer precinct, whoever's the last person to touch it before it's sent back, if we copy those, you keep a file of those, they give you a basis to step.
That would be actually, good way, like I said, to keep track just of what's there, because everything is, like I said, still paper. We still have to have them, still sign them, still have to return them to the board. So, yeah, I guess we could exactly do what Chief said.
I think that it's important to also to have specificity and clarity about what you're asking, because it's one thing that it's, if it's an order that's not been served, but for that one order, if it's a respondent who's on the run, multiple attempts within a 1 week period or within a 6 month period could be made. So I am not the chief and I am not an officer, but I would think that you're asking, was the order not served or how many attempts? Because there could be so many attempts for that one order that you would have to trace back.
Right. And I think, and overall, and just to be sure, clear too, having the data is one thing, and we don't want to just collect it for the sake of collecting it. I think the other purpose is the experience, or at least the anecdotal experience from folks that have, and I'm going to mix up the two, so forgive me, that's not my primary field. Asking for a peace order, not being served, consistently having to go to the court to then every month making a decision. Is this worth even doing? It's a tool, but it's not effective. I'm not even going to bother trying, creating a environment in which folks don't even want to utilize it because it doesn't seem to be effective. And while internally we're asking a specific thing of the police department, which you're providing based on what the request is, but the lived experience of folks that are then dealing with it is not meeting an expectation, which means that they're not utilizing it. How do we fix that? And if part of it is, if the question is, they're obviously going outside the department to try and get these papers served because they can't hold folks accountable until they're served. What can we do better to serve folks internally rather than forcing them either to quit or to find an outside way of serving these folks? And I'm saying, if you're doing the job you can and what's available to you, I'm trying to find out from the numbers how we can make it better.
I get that, and well, just to throw it out there, just so you know, these orders are given to the patrol officers, so the patrol officers are also answering calls for service.
Right.
That's coming in from 911, so sometimes they might not even get a chance to give service even that evening.
Right.
But just to throw it out there, we don't have a set squad that just.
Absolutely, and also too, and being not in your position, but we want to know the answers so that we can kind of address it, but also nobody's trying to hold anybody. Nobody's, there's no like the accountability piece, but also like, okay, so this is what we expect. It's not happening. How do we fix it? And not having the data in order to have a clear picture of what needs to be fixed. And then even when seeing it, like, you guys are messing up, like that's not even the case. We want to make sure that, like, all right, well, this is what's expected, and we want to make sure that expectation's met. So
you want
keeping
the victims to get what they applied for.
Right.
Two quick points. One is Dana Cowell made a good point in the chat, which is that the forms themselves need to be filled out in English, which creates challenges for people who don't speak English, or if they speak English, may have trouble with some of the language or the verbiage that, again, may be easier for someone who speaks English as the first language. I also wanted to mention that there is also a section of folks who don't call, who they're going through the process, but they're not calling 911 initially. And I say, again, anecdotally, when I was representing clients, there was a lot of cases where a client would call and say to me, a week ago, X, Y, and Z happened. What do I do? And this may be in the context of a custody or a divorce case. And they didn't call 911, although they were the victim of abuse. And so that is sort of a different, it still comes into the process when it comes down to service, but then they're going to, there's no 911 connection or initial police connection to the case. So that's a part of it too. And I think that, so on top of the numbers for the domestic abuse stats, there's also the people who are victims who are going through the protective order process, but not directly through, not through law enforcement initially, but through private counsel. And also I'd imagine through some of the pro bono work as well. So that's another complicating factor on some of the data.
I'm wondering, I don't know how you do this, but this is a stats and a coordinated collaboration of resources. But I would think that in many instances, sadly, there are other challenges going on in that family, and there's other service providers involved, right? There's children in that family, there's elders. They're also being abused, and they may be under social services and other protecting and protective agencies. So I'm also curious in terms of these numbers, how many of these families and individuals are also under care, the care or potential care of other service providers, right? So we're social services when it's also has children in that home and we're going through separation, divorce, or child abuse in and of itself. So I would think that some of these families, it's not just intimate partner violence or domestic violence. There's also child abuse, there's maybe child neglect or elder abuse, depending on how many generations are co-locating together, right? And so my point here is, I'm sure there's a lot of overlay, right? Or overlap between within and among these related individuals. And I'm wondering how we would either find out, within these homes and within these certain circumstances, how many of those individuals were looking for protective orders. And at the same time, it's the same family that we're dealing with in a custody battle. Or that there's been reports of child abuse prior to the domestic abuse. So I'm trying to find how many of these individuals and families are being affected in a variety of ways where we're serving them maybe through the school system, maybe through social services, maybe through elder care. And so there could be better coordination and collaboration, because I would venture to say that if those individuals, those respondents who are in a custody case, who are dodging their also protective order, we can find another way to find that individual.
And Delegate
Maybe.
White Holland, I think, kind of point that piggybacks off that, which is that there's our other service providers who may interact with families or individuals in the home are aware of these orders, and our agencies able to talk to one another and communicate in regards to that, which kind of gets that question of firewalls between agencies. But I think also,
So
there may be alternative means of service.
can I answer that also? I think I understand the delegate's question, but I don't think I think firewall is not exactly, it is all of our domestic violence service providers have confidentiality.
Right.
So we can only share information if it is, if we have a signed release of information, and therefore it is the choice of the person who's experiencing the abuse, where their information goes and how it's shared and what happens with that information. So I think that's just an important thing to raise is like, Darren could physically drop somebody off at our doorstep and then call me the next day and say, hey, I have something that I want to tell that person that I just dropped off this yesterday, or hey, I'm just checking in to see if they're okay. And unless that client gives me permission to communicate with Baltimore County Police Department, even if they physically, brought them to our doorstep, then our confidentiality prohibits that. So I think that when we're talking about the exchange of information and the knowledge of that, I would be remiss if I didn't bring that up, because, and I'm not saying it as a barrier. I don't think it's a barrier. I think it's part of empowering clients and them having control over where their information goes. But it is a factor in the work that we're doing. I think that's a really, really big piece of things.
One of the things that Turnaround and GBMC did and strengthening our partnership is we kind of do it on the front end. So when we get referrals from GBMC, when they're speaking, they're like, do you want to work with Turnaround? So we have the ROI kind of filled out, in advance. And of course, at any time, as we know, they can revoke it, but it just kind of removed that barrier. So that's also possibly an option. If you're working with someone, you're a referral, or you refer to another agency to kind of do it at the time of referral.
Because our agencies work together all the time. I mean, it's all the time. It's just it's just really, really critical that that's a decision that's made by the person who's experiencing the abuse.
And I know some of these cases get to be pretty intense, you know, some of the ones that you guys get involved with, especially with the police. And I know you guys kind of work together to try to do what's best for the client, and you guys try to, you know, communicate with the client. And there's cases where there needs to be more communication. You guys, I know, working with Ross in the past, that you guys facilitate that communication for us.
We'll say as Walmart makers, I think one of the best laws that have been passed recently was the letting us enforce the pretrial restrictions. Because it's like having a protective order in place until court. And a lot of that restricts the suspect from contacting or from going to the residence. And even if the victim didn't go down and get a protective order, there's one kind of in place by the court for at least 2 months. But that helps, and it's a great tool. So, thank you.
All right, well, thank you, officer, and appreciate your time in this presentation. I'll circulate this to the membership. I'll also get a copy of the pamphlet as well to provide, and we'll get that out to everybody after the meeting today. So we have on a slightly different note, we do have presentations from educators, and I know Tiffany Eshelman from BCPS has a presentation as well, so I will pivot over to her. Darren, thank you so much. Appreciate it.
Thank you.
Let me pull it up from her. And I know we're cutting it close to 3, and if people need to leave or hop off, that's totally fine as well. There's no issue there. So let me pull this up. And it's a little bit of a briefer PowerPoint, so let's hop on over to that. All right. And Tiffany, I think if you're unmuted, you can get going.
Great. Hello, everybody. My name's Tiffany Eshelman. I am in the Title IX coordinator for Baltimore County Public Schools. Thank you for having me. This is the first work group that I participated in. Can everybody hear me okay?
Oh, she's paused for a second here.
Can everybody hear me?
We can hear
now,
you on the webinar,
Okay,
yes.
perfect.
Okay, great. We just had to turn up the volume in the.
Okay. You can go to the next slide.
All right.
So what I'm presenting on is my role within Baltimore County Public Schools. Like I said, I am the Title IX coordinator for the county. So I address potential Title IX complaints for both students and staff. I started in this role in 2021, and my responsibility for BCPS is to ensure that we maintain compliance with the federal law, Title IX. And then my other role is ensuring that both students, staff, parents, guardians understand the Title IX process and are able to access resources that would pertain to it. When I came on board, there were new regulations issued by the Department of Education in May 2020 that changed the way LEAs respond to reports of sexual harassment. And one of those big changes required LEAs to create a grievance procedure for both students and staff to provide a formal manner for complaints of sexual harassment to be brought forth and to be addressed appropriately and within a timely manner. Within those regulations, it also includes that these allegations of sexual harassment, in order to meet the definition under Title IX, have to deny a student access to their educational opportunities, or if it's a staff member, to their work. It also is inclusive of only allegations that would occur in a context that BCPS exercises substantial control over, meaning it could be, a potential allegation of sexual harassment in a virtual learning session or during a sporting event or a field trip. But currently the regs are not inclusive of allegations of harassment or assault that might occur in the community where we would not have that substantial control over. So when I came on board, I created a student grievance procedure and an employee grievance procedure in cohort with other members from BCPS in their respective departments. And that is currently the investigative process and resolution process that would be moved forward if a complainant would want to file a formal complaint under Title IX. So when I am located in the Department of School Safety. So within my office is the school safety managers. They are assigned by zones, and they are supporting schools in all aspects of safety. Housed in our office is also our safe school facilitator, Sergeant Knox from Baltimore County Police Department. So although my presentation is geared towards Title IX, our office does get, reports of potential sex trafficking or abuse that may be happening at home. That is addressed through our office and then through other appropriate departments. But when allegations are brought forth, I can receive those allegations through the safety managers, through principals, school administration, through students directly. Sometimes I'll get allegations that are received by Sergeant Knox, really just a plethora of different avenues that I can receive reports. And the first thing that I'm going to do is I'm going to, consider what was presented and if it could potentially fall under Title IX. And then one of the big components of Title IX is supportive measures. So those are meant to be individualized supports to the complainant to ensure that if it's a student, he or she maintains access to education, that the harassment stops, and that they feel safe and comfortable in schools. And so when it comes to supportive measures, this is often when I am partnering with a lot of different departments, such as our Department of Social Emotional Support. So we do often have a lot of cases that may come forward that would require students to receive mental health services, whether it's through our school counselors, whether it's through our social workers. Each one of our BCPS schools also partners with an outside mental health organization. So Thrive, Turnaround, where students can, receive therapeutic services through them, whether it's going to come into the school or be outside the school arena. I'm just going to take a quick pause and see if there's any questions so far. Some of those other components of supportive measures would be, separating parties. So if there is a report that I received of an allegation of sexual assault involving two students that may have occurred in a school building in which they both attend, part of my job under Title IX is to ensure that those supports are put into place. So we often have to look at separating students, whether that be the least restrictive, such as a schedule change or, leaving class early, but then it can also be inclusive of a different setting, school setting. So is there a need for a different school for one of the parties? And so those are implemented whether or not a complainant wants to move forward with the Title IX complaint process. If the complainant does want to move forward with the complaint process, then the grievance process would be initiated. Like I said, we have both a student and a staff grievance process. And the grievance process, a lot of the provisions within are issued because of those Department of Ed regs. And the grievance process is quite a hefty process. It can take up to 60 days. There's a lot of provisions of interviewing and information that is shared amongst parties, which is often, in my opinion, intimidating for students to know that the other party might read their statement, etc. So there are definitely some interesting components to the grievance process that may be different from, just a school investigating an allegation and issuing the student handbook. Did somebody say something? I thought I heard a question.
I have a question.
Yeah.
Can you hear me?
Yes, I can.
Okay, great, thank you. Are the referrals for the supportive measures as well as the processes culturally responsive? So like not only talking about language access, but looking into if that student is part of a certain community where there may be, community norms or expectations that are
Sure.
taken into consideration.
Yeah, I mean, often because I'm located, I'm not in the school buildings, right? So my office is in school safety. So I often have to partner a lot with different staff within schools that would help navigate that process. If there's some cultural barriers, language barriers in regards to accessing supportive measures, it can also be through, the lens of a safety plan if that's needed, and working with both parent and student for that.
Thank you.
You're welcome. Any other questions? And the supportive measures are, I would say they're the biggest component to what I do, because there are quite a few allegations that will come through that might not meet the definition of Title IX. But I'm still working with schools, parents, students to make sure that there are supports put in place for that student, or if the student doesn't want to file a complaint under the grievance process, I'm still offering and providing supportive measures for as long as that's deemed necessary by the complainant. In regards to staff, allegations that could potentially fall under Title IX that involve staff, I often am partnering with our Human Resources Office, our EEO, and our Investigations Office, because there are complaints that might filter through them. And then they, give me notice of those complaints for me to reach out to the complainant to discuss what they've reported. When it comes to student cases that I receive, I oftentimes am going to schools, speaking with students directly through an interview or through the parent, depending on what the parent requests, if they want to be present during this. With the older students, I often like to speak with them directly, just so that they can understand their rights under Title IX, as it will be applicable to them when they go to college, and to just better develop their self-advocacy skills about what they need and how to represent themselves. If you go to the next slide. So this is just a current, just kind of snapshot. Like I said, I am getting anything that is sexual in nature. So any sort of report or incident that happens in a school building that is sexual in nature is getting filtered through me. That in no way means that every allegation that I receive is appropriate for resolution under Title IX, but currently that is our process to get filtered through me. So at this time, I've had 96 referrals. When I say referrals, I mean reports, whether it's through students directly or school administrators or the principal, Sergeant Knox, that are sexual in nature. And so the first pie chart that you see is showing the referrals by grade level. So definitely more in our secondary schools, middle and high school, as compared to our elementary, but still a significant amount of elementary base level referrals that I'm receiving. The little component is other. These were just referrals that I received where the allegations were involving staff that were in offices, not located in school buildings. So out of those 96 referrals, we currently have one that is going through the grievance process. That is, the complainant did wish to pursue. It was something that was appropriate under Title IX, and it's getting resolved through that once the police are done with their fact finding. This one was an allegation of a sexual assault. With Title IX, it does provide the complainant the right to decide if they want to move forward with a complaint. But when there are very egregious accusations, such as a sexual assault, I can initiate the grievance process without the complainant's consent to ensure that we respond appropriately and address the complaint in a timely manner. The other chart is going to show complaint types. So out of the most referrals that I've received, it is students making student-to-student allegations. So student A did something to student B. We have had quite a few students reporting inappropriate conduct by staff members. And then the smallest component that you'll see is student to other. These were reports that I received of incidents that may have happened in the community with a parent or with an adult individual that the student didn't know, but not a BCPS staff member or not another BCPS student. It's important to know that out of those 96 referrals that I've received as of today, 25 of them were occurring off campus. So the allegations of sexual harassment or sexual assault were occurring in the community. Whether that was, as an example, a party on the weekend that a student threw, or at the park, whatever that may be. So I'm still getting looped into those, although they would not be applicable under Title IX. I'm still initiating best practice and reaching out and speaking with the appropriate parties to ensure that there are supports in place, as well as to maintain, to check if there's any CRO, so community reportable offenses, if the police were involved and there is a CRO, if the respondent needs to be removed from the building, or if we need to make sure that the students are not in the same class or in the same building together.
How is that determination communicated to the families? One of the things that I often hear is confusion from parents with limited English proficiency about how students are separated and why one student is placed in a different school versus not.
Sure. I mean, if it is a Title IX complaint, there is, a look at if there's a safety risk involved, if there's an imminent threat. So we do have a school assessment team do a risk assessment analysis to help make that determination if we do need to make the most restrictive change of placement for the student pending the Title IX investigation. In addition, we partner with the language line or other departments where there may be individuals that speak Spanish or whatever that may be, to help me navigate those conversations with the parents or the students. Any other questions?
Actually, Tiffany, I had a quick question. So in the referral chart,
yeah,
it shows elementary is having 58 and middle and high school is 36. Is that accurate, or is it because you mentioned middle and high having more cases, but it looks like underneath of this, elementary is higher.
I believe that this would be, you're correct, a typo. It is middle high school, not elementary. So middle high school has more referrals than elementary, correct? And the elementary, I apologize for that. The elementary referrals that I get, just to give you an idea, I could get a referral, for a high school for an alleged sexual assault that occurred in the building. And then in the same day, I may get a referral for 2 first graders where one, touched the private area outside the clothes of another student. So, very, very different allegations and ways to respond in regards to supportive measures. So, working with mental health providers in the building to do good touch, bad touch, appropriate peer relations. Does there need to be school-wide sessions or classroom sessions on that? depending on the age of the students. So the referrals that I get they vary very much. So some common trends that I'm seeing, I get a lot of referrals for inappropriate touching above the clothes, whether that's slapping the bottom of a student or grabbing them without their consent. I would say that the biggest trend that I'm seeing is social media. Students with phones are taking photos, taking videos, airdropping, or another trend that seems to be happening is students hopping on group chats, group calls together and sending photos and videos that route. And then students within that group chat are then sending them out to other students. So it becomes very viral. So technology and social media is a huge piece, especially with our secondary students, and working with them and with schools to facilitate lessons on technology use and the impacts of technology, to try to make sure that students are aware of the power of a phone and the power of social media. Another big thing that I see a lot is just the concept of what a healthy relationship is with our secondary students, what it means to be respected, what consent means, what a healthy relationship is. And a lot of that is stemming from being able to have those lessons and to, be able to understand that perhaps they're not in a home setting where they get to experience a healthy relationships themselves. So oftentimes partnering with our, mental health providers, our community partners, to help navigate those conversations with students. Then some of the hurdles with Title IX. The grievance process is it's a very intense process for students, and it can be very intimidating to go through such a long process. There's a lot of information sharing and interviews, and for somebody who's very young, that can be a lot to take in and to want to pursue. In addition, the grievance process can take up to 60 days, which is quite long when you're thinking of school and how long the school year is. And how to, address the issues in a timely manner, but there are time constraints and provisions built into the grievance process that limits the ability, to speed it up. Supportive measures are offered throughout it, but still from beginning to closure can be quite long when we're thinking about a typical school year. Some other issues that we've ran into is just the school's capacity to separate students when there are very serious allegations. Part of that could be, transportation, or if a student has an IEP, trying to find another program or school that is able to still meet their IEP under IDEA, and addressing those components. With Title IX also, when there are allegations of a sexual assault, they are being referred to our school resource officers. And depending on if there is going to be a case generated, a CC number, Title IX would be on hold from interviewing any students until the police are done with their fact finding. So in that interim period, we are offering supportive measures, but in some cases, there's a delay in interviewing the respondent or any witnesses until the police finish their fact finding, so that we don't interfere with their investigation. And obviously another hurdle is just reporting and making sure that, students, especially students, are aware of their Title IX rights, understand who they can reach out to, who they can speak to. We have, last school year, we did partner with Turnaround at one of our middle schools that was having a lot of allegations that were sexual in nature, and they came in and did some lessons with students and with parents on consent and just appropriate behaviors, to help, give more knowledge to students. I do trainings with all school administration a couple times a year to make sure they're aware of reporting rights and how to make sure that we're addressing allegations that could potentially fall under Title IX. We also have posters with a Title IX QR code that sends the viewer directly to the Title IX website where they can receive Title IX information, resources, my contact information, and if they want it to remain anonymous, how they can do all of those components to just make sure that that information is getting out there.
Does the training include, the trainings that you provide, does include information on how to work with multilingual, multicultural families and some of the immigration consequences to having an allegation of abuse against a student, or some of the immigration benefits that could happen for the student that's victimized?
Does the grievance process include that?
The trainings that you provide.
So the trainings that I'm providing as the coordinator are surrounding the grievance process and how that would unfold and the reporting requirements. So they would not be inclusive of that, but I mean, I would be partnering with other offices to help address that. But no, those, my role within that would to ensure compliance and to be able to explain the grievance procedures to school administration. Any other questions? I've put my information on this page to reach out with any questions. I also manage the Title IX mailbox, so that would be me as well. In addition, if you visit the BCPS homepage, there's a Title IX footer at the bottom, which will take you directly to the Department of School Safety, and you're able to access different Title IX resources on there. That would be inclusive of the student grievance process, the employee grievance process. There's a Title IX FAQ. There's a meet the Title IX coordinator to just understand what I do. And then there's some trainings that have been completed by me through a TICSA on that website, and all that information is available for anybody to preview and access.
All right. Any other questions? Not. Thank you, Tiffany. Really appreciate you taking the time to come in.
Thank you.
Present, rather. All right. Anthony, if you want to come up and sit, we can catch in the microphone there.
There's a microphone.
There's mic. Yeah, you can sit right there or you're in here. Either way works. Up to you. That's all right.
Sure.
See ya.
Okay. Can everyone hear me? Okay.
Yes.
So, all right. So how you guys doing? My name is Anthony Davis. I am the interim Title IX coordinator at Towson University. Much of what Tiffany's mentioned is my job responsibilities as well. I'll just go over, I guess, the differences, so that way I'm not reiterating everything she just mentioned of our duties of a Title IX coordinator. So a part of my job as a Title IX, well, actually, let me give you background. So I've been at Towson University for about a little bit over a year now, started in October 2022. I started as an investigator, Title IX investigator, and then I'm currently in the interim Title IX coordinator role, soon to be permanent role. So I'm looking forward to that. So the difference between the investigator, I would just conduct an investigation specifically for allegations such as sexual harassment, sexual assault, and other sexual misconduct. And now in my Title IX coordination role, I am I'm meeting with students as well as staff and faculty members or whoever on campus that allege sexual assault, sexual harassments, or other sexual misconducts. The other sexual misconducts is identified as such as sexual coercion and sexual exploitation. So if any of these parties want to come to my office to disclose those type of allegations, I meet with them to provide an intake meeting. So what that means is that I discuss the grievance procedures. The difference between myself and Tiffany's procedures is that our policy is the same procedures for both students and staff and faculty members. Yeah, so there's not two different procedures for that. We do have a different procedures for a non-discrimination process, which also covers sex, discrimination based upon sex, but it also covers other protected classes such as race, age, disability, things of that nature as well. Which of course our office also investigates as well. And the office that I work for right now is Office of Inclusion and Institutional Equity. Okay, so pretty much when a student comes to our office, student, staff, or faculty member, whoever, comes to our office to report an incident of sexual harassment or other sexual misconduct, I meet with them as a Title IX coordinator. I provide them with their role, their rights and responsibilities as the student or employee of Towson University. I let them know that they have a right to supportive measures. Our supportive measures is a little bit different from Tiffany's, which she mentioned. Our normal supportive measures is a no contact order. A no contact order is administrative equivalent to a protective order. So it's just administrative directives that states between the two parties are not allowed to speak directly to each other. That includes in person, that includes social media or text messages, as well as through a third party. If either party needs to speak to each other, they contact our office first. So that will be supportive measures. Other supportive measures would be room transfers, academic accommodations, things of that nature. So we can provide the supportive measures regardless of whether or not a party wants to move forward with a formal investigation or an informal resolution. For it to go to an informal resolution, both parties would need to agree a part of that informal resolution process. It could be mediation or it could be another alternative resolution as well. The regs as well as our policy give us leeway to how we handle that informal resolution. We cannot offer informal resolutions for incidents involving sexual assault, sexual coercion, or if the responding party is an employee and the reporting party is a student. So if both students want to move forward with a informal resolution, we go that route. But if a student wants to move forward with a formal investigation, we let them know of their rights, as they can have a support person. A support person is just someone who could participate in the role of the grievance procedures, but has no speaking rights within this process. They just there to provide them emotional support. And then we also have an advisor. The role of the advisor is to be that party's talking person for them, like talking proxy. By the way, if anyone has any questions while I'm talking, feel free to stop me. If y'all let me, I'm just gonna keep chatting. All right. So, yes.
I have a question, actually. So what do you do with a sexual assault? If they come reporting a sexual assault?
Mm.
Do you automatically turn it over to the police? Because over 18, it's not a mandated report.
Mm-hmm.
So.
Yes. So great question. No, we do not automatically turn it over to the police. Yeah. What we do is we leave it up to the reporting party. If the reporting party wants to, of course, we provide them with information such as our TUPD. But if they do not decide to move forward with contacting PUPD for the legal process, then we're not going to force them.
Okay, because I can tell you that the numbers that you might have really are significantly higher, because when I was still working at GBMC, we got quite a few students that would come in and go the route, opt for an anonymous kit.
Mm-hmm. Yeah.
So because they didn't want to report to police, that's why I was just asking.
Yeah, for sure. And in a little bit, I'll get to the trends as well of that as well. Where was I? So yes, I was talking about advisors. The advisors are the purpose of the advisors is to be a talking person during the hearing, during the formal investigation process. Parties are not allowed to speak directly towards each other during these hearings. However, they are allowed, due to the new regulations in 2020, they are allowed to have cross-examinations. So they will, if they have any questions for the opposing party, they will provide those questions to the advisor. The advisor will ask those questions to the other party, and then the party will answer the questions during the hearing. So that would be the purpose of that. For the advisors, they can be an attorney, however, they don't need to be.
Anyone be an advisor, or is there like a parameters for that? I mean, I know they don't have to be an attorney, but they need to be, like, is there anything, or is this up to the party?
Gotcha, yeah. Anyone could be an advisor. We do have trained advisors employed at Towson University that if someone doesn't know who can be an advisor, we can appoint them to be an advisor for them.
Okay.
Yeah.
And that's something that they just receive once the investigation is completed, they automatically get an advisor?
We appoint them as soon as the formal complaint is signed. So by the reporting party / impacted party.
Okay.
Yeah. However, they have the right to choose their advisor should they want to pick someone specifically to be their advisor.
Okay.
Yeah. So I talked about them, talk a little bit more about the process to the reporting party during the intake meetings. Then should the party wants to move forward with the formal investigation, I send the formal complaint form to them. They complete the formal complaint form, and using the submission of our discussion during that intake meeting. So I will draft up a summary of what we talked about of the allegations. I will send it over to the impacted party / reporting party for their confirmation that everything is accurate. And then they will attach that to the formal complaint form. And then from there, we will issue a notice of investigation / allegations to the responding party and CC the reporting party as well. Just let the responding party know that there's a formal investigation has just begun. And again, issue the same rights of having the advisor, of having the support person, the informal resolution route should both parties choose to go that route. Everything in that investigation report, in that notice of the allegation. And then from there, we will begin investigation. So in my previous role, I was an investigator. So I used to be assigned, but now other advisors, other investigators are assigned to investigate the allegations. So that consists of interviews of the reporting party, if the investigator needs additional information that I missed from my initial intake. The investigator will interview the responding party, witnesses, gather up any documentation that's relevant, such as text messages, screenshots of any type of stalking allegations, things of that nature. And then that party completes the final investigation report. They draft up the final investigation and then send it to both parties. Both parties have the option to review the report of what the investigator compiled together. And then they have 10 calendar days to provide a written determination. A written statement regarding everything that was provided in that report. So they have the opportunity to look at all the witnesses say, all the opposing party, and then they have the opportunity to say, well, that wasn't accurate. This person is not telling the truth. This is what really happened. So then that period is over. We send that report to our legal team for legal sufficiency review. After our legal sufficiency review, which is usually flawless because we do an excellent job in our investigations, and then we send it off to the parties for the final investigation report, and then we move on to the hearing, which is again a big challenge for us because bless you. Because we partner with a third-party organization called Grand River Solutions for our hearings. So we used to have internal decision makers, people who work with us within the student conduct department. However, being the decision maker in these processes is just too time consuming for them. They have many allegations themselves working through the student conduct. They can't be adjudicating our Title IX cases as well. So we partner with a third party called Grand Rivers, and they take an extremely long time providing us with a decision maker. So that's the challenge that we have right now. So Title IX reg says is we have to resolve our allegations within a timely manner. And our grievance procedures is usually about 6 months minimum. So, I'm sorry, you had a question?
No.
Okay.
That's a long time.
It is a long time. Yeah.
Yeah.
Yes, it is a long time. 6 months. Yes. So, sorry. Yes, it's a long process. Yes.
And did you say that's just to get the decision maker or to get the decision, like to have the
Through
whole
the whole
hearing?
process. Yeah, through the whole process. Yeah.
I mean, that's crazy considering that the school year is only 9 months long.
Mhm.
Yes.
And they're in school.
Yes.
And they're walking past their, the person who supposedly.
Yeah.
All the time.
Yeah.
And how typical is that of you and other schools in Baltimore County? Would you know?
I do not know. If I'm being honest with you, I don't know other schools' response times with that. I do know just from, again, I started here in October 22. There's been a high turnover rate within our office. So I think between my time, 3 people has come and gone. No, 4, sorry. 4 people has come and gone. And then there's 3 people before me. So.
I'd also be curious if that is like the average amount of time, or if it's like dependent on the size of the school. Like if we're keeping it in state, if you were to look at like, like Post College in Frederick, that's a lot smaller, as opposed to Towson, that's so much bigger, as opposed to University of Maryland College Park, that's really big. What the time, if the time frame varies, if so.
Yeah, that's a very good point. I would assume it would be the same. However, the same regarding Towson and College Park, considering we're the 2 largest public institutions in the University of Maryland system. However, I think it also comes down to the resources as well. So right now we're a team of 3, including myself, hoping to gain 2 more investigators and a data analyst.
How many incidences are you addressing right now in this calendar year?
Gotcha.
And are we seeing trends increasing, decreasing? Do we have any data? Any stats?
Gotcha. Yes. So we usually see more cases in the fall semester. That's been my experience when I worked in student conduct, as well as my experience working in Title IX as well. So in the fall 23 semester, there's been 106 cases, including repeat cases. 10 of those were dating violence cases, none for sexual exploitation, 3 allegations of gender/sex discrimination.
How many was that? The last one, the gender
3.
sex discrimination.
3, yeah. 25 allegations of sexual assault. Sexual assaults includes forcible rape, forcible fondling, as sexual assault on object, incest, and statutory rape. And 20 allegations of sexual harassment, none for sexual coercion, 11 allegations of stalking, and then 38 reports of pregnancy or reports that did not fall in our jurisdiction.
And how?
Wait, I'm sorry, can you repeat the pregnancy or things that did not fall under your jurisdiction?
Jurisdiction, yeah. So if it wants student conduct, instead of us.
So if a student becomes pregnant, they report it?
Say again, I'm sorry?
You said pregnant, right?
Pregnancy, yes,
So
yeah.
if a student gets pregnant, they report it to the inclusion and institutional equity office?
Yeah, if it's pregnancy falls under Title IX as well. So we provide accommodations for students, not employees. HR handles that, but we provide accommodations for students. Yes, so Title IX has
needs if you're pregnant with a student versus a student who's not.
Right.
You don't want to have discrimination against that or allegations of discrimination because someone has different medical needs.
Exactly. So yeah, Title IX has 3 prongs that is covered within Title IX. The first one is sexual harassment. The second one is pregnancy, and the third one is equality in athletics.
And I know this is a guesstimate, but those are the known cases? How many are unknown?
That part. Yeah, Yeah.
More.
yeah,
Right.
for sure.
We can assume more, but how much more? Because I think that part of what needs to be addressed in the previous conversation and this one as well, which is, this is what we know, and this is who we're serving.
Right.
More importantly, who are we not serving?
Exactly.
Because either they don't know or they don't feel confident or comfortable coming. Okay.
And like I said, there are many that have come for anonymous exams
Without going to the school.
without going to the school.
Mhm.
So I know that number is higher,
Yeah, for sure.
significantly higher.
For sure. Yeah. And I'll just skip to the trends of the trends of what we've been seeing on campus. Okay, so the students don't want to move forward with the formal resolution because it takes too long. So 6 months is a very long time. Oftentimes, students complain that they feel like they've been re-traumatized, specifically by the impacted party, because they repeatedly talk about their allegations of sexual assault over and over. So they talk about it with myself in the initial intake meeting. They may not have to talk about it again with the investigator if the investigator needs additional information. And then lastly, they talk about it again during the hearing process. So students don't want to, especially the impacted party, don't want to be re-traumatized. Another challenge is that parties want in due process, however, does not want to be cross-examined by the responding party through their advisor. And in addition to that is that many students feel as if the other party, the opposing party, has more money, so they can afford an advisor, afford an attorney. In which case they feel they won't have an equal chance of getting due process, so they don't want to move forward with the formal investigation.
Do the parents automatically find out about it?
No.
Okay.
So yeah, we would need a verbal release form signed, and they would need to contact, the student needs to let us know that, hey, I would like my parents to have information regarding these allegations. Yes. Typically, students do not want to move forward with a formal investigation if they were denied a protective order by a judge. Of course, the academics is being negatively affected by the incidents of discrimination. So we receive high requests for academic accommodations from students who allege some type of sexual harassment or sexual assault.
As a corollary to that, does Towson track any data about students who leave or don't return for another semester or for another year based on allegations of Title IX violations? I know that would be really difficult because you don't have to give a reason if you just don't come back, but is there any outreach made to students who leave to see, hey, why did you leave? That seems like something that would also fall under other reasons too, like if it's, academic struggles or, not losing your spot on the team. If you're an athlete, I can imagine there's lots of reasons, but I can imagine one of those could be you have a very traumatic experience.
That's a great point. To my knowledge, no. I would assume there would be a different department other than our department if they conduct exit interviews about why a student would leave. But that is something interesting. So I would definitely bring up to my supervisor to see if we could potentially put that in place.
Because I'm not trying to make this seem negative, but if I was a student who was a victim of sexual assault and I maybe had a little bit of info about the process and knew it's going to take 6 months, it's noted that's most of the school year. And if it happens in like February, you may be thinking, this may not be resolved, this probably will be resolved until the end of the year. Do I really want to, pay for next year's tuition or ask my parents to deal with that? And I know that with housing, there's a lot of, off campus don't want to deal with housing. And it can I could imagine it could create a situation where you're thinking, this isn't going to get resolved. I'm going to run into this person, in class or off campus. I'm just going to go home. Even if it is returning for another year, taking like a gap year in between. It's a pure spitball, but it just seems to me like that could be a situation. And I just think it may be useful to look into that and see if there's a way to track that without while walking the fine line of you don't want in an exit interview to ask every single student, hey, did you have a traumatic experience on campus that led you to leave? Because that could be
Dramatic.
traumatic in its own right. And also skirting the line of some privacy violations. So
So, so that 6-month period, is that allowable as a result of policies that are not put in place that are forcing that period of time to be far shorter? So my point is, if there were policies in place either in the county or the state, which would be forcing you to provide those services and those resolutions in a very timely manner, like 30 days. What would be the process in order to support the university in providing a resolution within 30 days, let's say?
I think that would be a resource problem for our institution specifically, because again, we partner with that third party vendor that just is not able to provide us with the resources that we need as a decision maker to get it done.
Using that third party provider.
We're in a contract. This is our first year, so we only we got in them.
oh, what was that? Sorry.
Nothing. I can't comprehend.
Gotcha.
It's contracts.
Nor do I accept that.
Yeah, we're also working. We also partner with another organization called ICS too. So we just got into another contract with another company for doing the same thing.
So I gotta ask the question, for a legal perspective, based upon Title IX, wouldn't you be subject to legal ramifications for waiting 6 months in order to respond? I mean, from a federal law perspective? I mean, where's due process? I don't know, I'm not an attorney, I'm only a lobbyist for children and families. But I'm curious to know if there's, I would think that's in profound violation of due process under Title IX.
So it's within our process. It's within our policy that stated that it can take specifically 6 months, and then it says that our office will provide a reason if we need more than 6 months.
And that's the policy of the university.
Correct.
And you're not aware of what policies are among your colleagues?
Well, the Title IX regulation says in a timely manner, a time resolution, but it doesn't give us a specific date of an interview when it needs to be completed. That makes sense.
Does that make sense?
Any other questions? Well, thank you so much for coming in and presenting today. I know, and it's a long meeting to sit here and wait to present, but I appreciate you coming nonetheless. And I appreciate everyone who stuck around. I'm going to send this out in the email as well, but I did want to mention, so looking at our next meeting in June, giving people enough time to clear their calendars and also to assemble and have a look at the data internally, find the best way to present that. Because again, as I mentioned at the beginning of the meeting, way back at 1, we are going to be looking at the data from the providers and internal data as well, and hopefully presenting that out there in some form. We're still working on the best way to do that, but the idea is to now we've covered a lot of ground on talking to the challenges from the providers' perspectives, looking at the housing issue, looking at educational issues, and looking at the most common law enforcement issue that people interact with the courts on, which is the protective order and peace order process. And now I think the hope is to transition to, now that we've kind of gotten the big picture, diving more into the details and looking at where the data leads, because I do think that's kind of the next step of saying we've received some data today and the general data from the department, but also looking more at where are the trends and where are the emerging issues and what are providers seeing that is a growing concern? What are areas that may be stagnant, and make sure that as this working group goes on summer and the fall, that we're, as we look to the end of the year with making policy recommendations, that those recommendations take into account where we headed as a jurisdiction in these challenges. Because I think that's, in terms of proposing solutions, we need the numbers as well as the stories. So with that in mind, we'll adjourn unless there's any other questions or comments, and I will be sending out copies of the PowerPoints as well as the pamphlets to the members of this working group. And that way you all will have that, and appreciate the time and the effort everyone's put into this so far. And I think we're making good progress. So thank you all.
Thank you.
Thank you.
Of course, appreciate it. Thank you for being here.